clearly comes out a defined relationship, which may not be contractual under this agreement. Lord, I hope, Lord, I am able to make myself clear. Lord, continuously, my Lord, I am saying, my Lord, in their contract, Mr. Khambata and Mr. Devan's contract, they continuously refer that the goods will be supplied by Mr. Mehta. I am not, my Lord, a document signed by the parties. I am not a signatory to that document. But from the document, it emerges that there is a defined legal relationship emerging from that document. Like, for example, there are certain obligations incorporated by reference. They can say, Mr. Khambata can say that I'll supply goods to Mr. Devan, but we have a separate agreement dated so-and-so, registered at so-and-so with Mr. Mehta, and he has agreed thereby that he would supply the similar goods to me, which I will supply to him. So
I may not have bargained for a contractual relationship between you and Mr. Devan, in your example.
Yes.
Unless there is a tacit acceptance by you of the obligation which Mr. Khambata has assumed to supply goods to Mr. Devan, you would not be liable.
No.
Merely because, say, suppose, for instance, you are the foreign collaborator of Mr. Khambata's client. All right, that you are the person who has prepared the software, or you have prepared the service agreement, the license agreement. You are the real originator of it all. Unless there is something to indicate that, look, you have assumed the obligation, or that you stand behind the obligation which Mr. Khambata has assumed to.
I vouch. Yeah. That is why I emphasize it must emerge a defined legal relationship with respect to the dispute. I'll just give an example, simpler example. Look, Tata Steel is a Tata group of companies.
Yes.
Tata Motors is a Tata group of companies. Suppose Tata Motors enters into an agreement with me for buying certain products, tires, machinery, etc., etc., and there is a dispute between the two of us. I can't involve Tata Steel saying that it's a group of companies. If he is unable to pay, you pay. But if there is a defined legal relationship with third person, and that is how, my Lord, the courts have construed. Defined legal relationships are presumed under various doctrines which your lordships have evolved in other jurisdictions also. Back-to-back contract is one such thing. It would be a fact-specific determination.
Right.
There would not be any, my Lord, straight-jacket answer. But the point I am respectfully urging for your lordship's consideration is there is no exclusion. In fact, Section 7 incorporates group of company doctrines by not restricting it to mere parties to the agreement, except in 4.1a, 7.4a, but it restricts even correspondence. There can be a correspondence that, all right, we supply, they supply, etc., etc. Lord, now kindly come to page 10. It is thus clear that even if there is a contractual document in existence between party A and B, as contemplated under section 7.4, I'm sorry, page 6,
Page 6, yeah.
Page 6. It is thus clear that even if there is a contractual document in existence between party A and party B, as contemplated under section 7.4a, if both of them have a defined legal relationship with entity C or D, qua the dispute, not, my Lord, some other relationship. I am now, my Lord, restricting to give a purposive meaning, my Lord, and to ensure that it doesn't become an unruly horse where anybody and everybody